आज सिद्धार्थ मिश्रा वर्सेस यूपीएससी मामले में केट द्वारा फाइनल वर्डिक्ट अपलोड कर दिया गया है। यह वर्डिक्ट 20 पन्नों का है, जिसमें से 15 पेज केवल आर्गुमेंट्स से भरे हुए हैं तथा 5 पेजों का ऑर्डर जारी किया गया है। उस 5 पेज के ऑर्डर को वर्ड बाय वर्ड इस वीडियो में अपलोड कर दिया गया है और ऑर्डर का मूल क्रक्स यही है कि जजेज ने यह माना कि हम लोग कोई एक्सपर्ट नहीं है, इसीलिए हम लोग इस मैटर में इंटरफेयर नहीं कर सकते हैं और यह ग्रीवांस केवल 14 लोगों का है तथा यूपीएससी का आज तक का रिकॉर्ड है कि उन्होंने फेयर एवं ट्रांसपेरेंट मैनर में एग्जाम को कंडक्ट करवाया है और डेप का प्रोसेस पहले ही पूर्ण हो चुका है, इसलिए नए अभ्यर्थी अब इस एग्जाम को दे भी नहीं पाएंगे तथा हमारा कॉन्साइंस कहता है कि जो 33% का बेंचमार्क है वह पहले ही बहुत कम है और 33% के रूल में परिवर्तन से मामलों की बाढ़ आ जाएगी कोर्ट में तथा नियुक्तियां प्रभावित होंगी, इसीलिए इस केस को डिसमिस्ड किया जाता है और 5 पेजों का ये ऑर्डर कुछ इस प्रकार है।
We have heard the learned counsels for the parties at great length. Besides meticulously going through the pleadings on record, we have also given due consideration to the plethora of judgments quoted by the respected learned counsels. 19. At the outset, we would like to recognize and expressly state that the UPSC carries an unblemished reputation and record of conducting examination for selection to civil posts in a fair, objective and transparent manner. We also note that apart from limited insinuation that the civil services examination, which is the subject of the SOYA, could have given undue advantage to science background students, no other aspersion has been cast upon the organization nor any other extraneous motive attached. 20. We are also conscious of the confines of our powers and jurisdiction and have no doubt that we are neither authorized nor qualified to sit on the judgment over the wisdom of the academic experts who have prepared the question paper which is the subject of the SOYA, i.e. CSAT. Paper 2 of the Civil Services Examination 2023. We find this argument to be a bit curious that the paper was 16 OA, no, 1782-2023, supposed to be of class 10 level arithmetic, but it had questions of class 10 plus 2 level, i.e. of the level which the candidates answer while appearing in admission test for higher engineering institutions. Now the applicants before us are aspirants to the highest civil services of the country. Why should they be intimidated by a class 10 plus 2 level paper? Does not stand to reason. Moreover, as mentioned earlier, we do not have either the authority or the expertise to determine whether it is so. 21. We do appreciate that Shri Salman Khurshid, learned senior counsel appearing on behalf of the applicants, has fairly suggested that in view of the limits of our jurisdiction, we should consider referring this matter to a committee of experts to determine whether the contentions of the applicants with respect to out of syllabus question is correct or not. However, acquiescing to this would mean prima facie accepting that the CSAT Paper 2, which is only a qualifying in nature, does suffer from lacunae and calls for a review. 22. It is not disputed that nearly 6 lakhs candidates participated in CSE 2023. We have only 14 candidates before us. Should an examination process of this magnitude, once set in motion, be interfered with? Our decisive answer to this question would be in the 17 OA, no, 1782-2023, negative, unless there are overwhelming circumstances and evidence of violation of statutory provisions of rules or some blatant miscarriage of justice. Such situation does not even remotely exist. Learned counsel for the respondents has emphatically stated that the examination has been conducted strictly in accordance with the rules and instructions, and the applicants have willingly and voluntarily participated in the same. Moreover, we notice that the qualifying marks of 33% by themselves constitute a low benchmark. It would prick our conscience if we were to contemplate lowering this abysmally low benchmark any further. The scheme of the CSE is elaborately defined and notified. The relevant extracts have already been reproduced in one of the preceding paragraphs. It is not the case of the applicants that the scheme has been compromised in any manner in CSE, which is the subject of the SOIA. 23. We would like to emphatically reiterate that we do not enjoy any right or authority to question the wisdom and knowledge of experts who have set this question paper, and further we are clear in our views that their decision is not amenable to judicial review. 24. Moreover, perhaps it is the anxiety of the applicants that they may not have performed well as they probably 18. OA. No. 1782-2023 found the question paper to be of a difficult level that finds expression in the SOIA. They may have tried to draw support to justify their claim by pointing out that questions were out of syllabus. We have no doubt that it is not for us to question the same, since the question paper is the creation of academic experts. If we were to entertain such applications and showing indulgence, it may open a floodgate of several such petitions, thus disrupting the entire selection process, that too often examination which is well established and whose integrity and transparency has not been questioned. We reiterate that UPSC is a respectable constitutional body, and even a hint on our part could have an adverse impact on the functioning of such a body. 25. As brought out during the course of arguments, in further developments, the result of preliminary examination has already been declared, with 14,624 candidates having been declared successful. None of them is a party before us. Moreover, the CSE is now entering its second stage of the main examination, in which these successful candidates will participate. At this stage, no interference is warranted or called for in this process. 19. OA. No. 1782-2023. 26. Against the background of what has been detailed and discussed above, we are of the well-considered opinion that the present original application is misplaced and devoid of any merit. Therefore, it stands dismissed. Pending MA, if any, also stand disposed of. There shall be no order as to costs. Pratima K. Gupta, Tarun Sridhar.